All right, I think we are live. Let me check here.
I just gave it permission on my end.
And that might be us. Okay, we are live. Hey, everybody, it's Uncle Grumpy, and welcome to Grumpy Tonight. Thank you for joining us. If you don't mind, please share. I'll try and pass this around to a few places, but it'd help if you guys would spread it out too. As you can see, we've got a house full tonight. We have, as always, Dr. Lawrence Pasternack. Hello, Lawrence. We have a return guest. Raymond Storm is back again, twice in 1 week. And we have Deb. I'm not sure if you've been on the show before. I think you might have been.
Not.
Okay, well, maybe you haven't. So we have Deb Holden tonight. She's a newbie to the show. So, Deb, I appreciate you coming on. Let's start with you since you're a newbie to the show. Tell everybody that doesn't know who you are, just a little who you are.
I'm a patient. I worked on 788 from the get-go. Worked on petitions before that. I'm a longtime advocate for legalizing marijuana in this state, and it was marijuana when I first started. There wasn't anything medical about it in the 70s and 80s. So this is kind of a bucket list thing. I'm really glad to see this legal in Oklahoma. I've continued as a patient advocate at the Capitol. I hope to be more active this next year. I believe that the even number years are better for us because people are facing re-election. So that's what I do.
Okay, so you've been doing this quite a while then, I guess, huh?
A while.
Well, we are lucky to have people like yourself in the cannabis community that have been doing this for decades in some cases. So that's great to see. Raymond, how's your week been going? You were here the other day, but how's it been going so far? You're muted.
Going good.
Okay.
Can't complain. It's awesome to be on the show with everyone.
All right. Well, I appreciate you being here. Lawrence, let's go ahead and jump in and get started on what we want to look at. Tonight, we want to take another look at the petitions that ORCA, the organization, has put out recently. Hopefully, all of you saw my show last night when I was talking with Jed Green, head of ORCA, about what's in these petitions and our different views of what we think belongs in there and what we think should go in the Constitution. But so tonight, we're going to take another look at them. Lawrence, you start by, if you don't mind, showing us one of the petitions, whichever one you've got ready. And let's take a look at the medical petition there you could pull up. Maybe we could start with the patient rights. I'd like to get a look. I know most of the patient rights are pretty set so far. There's not going to be a lot of changes. I'd like to just explain to everybody again, if we could, what those are again, and ask Raymond and Deb here if they think that everything's getting covered and what they might think about it. Should have screens if you want to use it.
Great. Just to start out with, any questions anybody has, just type them into the comments. I keep on looking back and forth at those comments. So if you have any questions and you want us to go over anything, please put them in the comments and we'll keep track of it. Just sort of setting things up. Probably a lot of people who are viewing tonight have seen one of the other videos that we've been doing. But there's two separate petitions that are currently being drafted. And we're seeking public comment. So this is being run by Jed Green and ORCA, and we're helping out. And there's going to be a medical petition and a full access petition. And basically what the medical petition does is it takes our existing programs, basically as structured by 788, and changes the regulatory structure to something that is seen as superior, beefs up some of our patient rights, and wants to put it into the Constitution. And then the full access petition, we have been calling it a plug-in because the idea is that it basically is not going to do anything other than say that anybody 21 or older is allowed to purchase and grow and consume cannabis. So take the existing program as it is and just add in anyone 21 and older and also include retroactivity, which means that anybody who's been charged with any criminal offense, that criminal offense gets vacated and the record gets expunged. So those are two separate petitions. One could pass, both could fail. They operate independently of one another. And so that's basically the strategy. Now, with that being said, Chris, you wanted me to start out with the medical or the rec, did you say?
The medical. I'd like to look at the patient protections and ask Deb and Raymond if they think that everything has been covered and what they might think needs to be added or adjusted.
Okay. Gotcha. So the basic framework, and let me put up a link here in the comments, orcaok.com. So anybody wants to find these petitions, read along, submit suggestions to ORCA, you can go to ORCA's website and they have links to the draft form of the petition. They get tweaked on a constant basis, but you'll be able to see the current form of those petitions on the ORCA website. And there's a place where you can enter in comments, and we're getting some pretty lengthy comments. I was sent like 3 pages worth of comments today to review. So they're coming in, and when they come in, we really are reading and discussing and thinking about those. So everybody don't feel like you're going to be ignored. Certainly feel like, when you submit something, that it'll be reviewed by the people in the drafting committee, and we'll seriously discuss it. Okay, all that being said, now let's go on to the medical petition. Okay, so first of all, the first 17 pages, give or take, of the medical petition has to do with restructuring the OMMA and renaming it the Oklahoma Cannabis Commission. We're going to sort of skip over that. I'm sure we'll probably get back to some of the issues, but we're going to start out today by talking about the patient protections. So let me do a screen share, and here are the patient protections that begin right here. Okay, patient and caregiver possession rights. So Chris, would you like me just to kind of summarize each section?
Sure.
Yeah. And by the way, hi, Robin, hi, Chance, hi, Jackie. Thank you all for joining us. First of all, patient and caregiver possession rights. Pretty much it's about the same as 788 with just a couple little tweaks. Rather than saying 6 immature plants and 6 mature plants, we just say 12 plants, because leave it up to the person how many they want, mature versus immature. And then we added in suppositories, which hasn't been put into law. All the rest of it is either 788 or some enhancements above 788 that we've been able to do recently, like including legalizing topicals, which weren't mentioned in 788, and allowing people to possess the entirety of their harvest. Clearly legalizing marijuana paraphernalia. And by the way, we just wrote the definitions for these things today. So people have questions about the legal definitions, we can go to those. If you grow or process any amount in excess of it, you just have to get a business license. So if you grow 37 plants or whatever, basically that says you need a business license.
Okay, but as long as you keep your plant count right, then now you'll be able to, you can now, as of November 1st, you'll be able to, but then also this reaffirms that you'll be able to keep everything you grow, right?
Yeah, so one of the changes that we accomplished at the legislature this year in House Bill 2646 is out of the plants that you grow at home, if you grow 10 pounds of cannabis out of those plants, it will be legal for you to possess it as of November 1st. So any amount that you grow, any volume of cannabis that you produce will be legal for you to possess, and that's in here as well. And so the next one is that currently the law is based on 788. If you don't have a patient card, it's still a criminal offense to possess cannabis. It's still illegal and it's still a crime. It's a misdemeanor. And so what this does is it will make it just a ticket, a civil infraction. If you don't have a patient card and you have cannabis on you, a police officer, he can't do anything more than issue you a $400 ticket. And if you go ahead and you get yourself a patient card after you get that ticket, within 45 days. You can go back to that law enforcement and say, now I'm a patient, and they will remove the $400 fine.
Okay, before we go on any farther, go ahead and shrink the screen for a second. I want to ask Raymond and Deb a couple questions about the possession limits. As you guys heard, Lawrence has explained, they're pretty much the same as in 788, except for, as we've said, you'll be able to keep what you grow, plus you'll be able to have 8 ounces of store purchased. Do you guys think that the 8-ounce possession limit, if we're going to do a new constitutional amendment, do you guys think maybe we should be upping that? Or do you think that we should be leaving it at 8, considering that's then going to be the maximum you're going to be able to transport to a processor too? So if you're a home grower, you're going to have to take it 8 ounces at a time. To the, if you grow a pound or two that you want to have processed.
No, that's not correct.
So you'll be able to carry more than the 8 ounces with you.
Yeah.
I know you can keep it home. I know you can keep it home what you grow, but will you be able to carry it with you everywhere?
Yeah.
Okay. Well, I guess that
How much
covers
can you carry with you right now? Like
3 ounces.
3 ounces. That's how much you can purchase from a dispensary.
Yeah. Well,
Why is it that right now? Why is it 3 ounces?
That's
Okay, they're not
788.
supposed to sell you more than what you can legally carry. That's the only reason why you can only buy 3 ounces.
Yeah.
So
Okay.
in other words, you can leave and come right back
Okay.
because they're not limited on what they can sell you. You're limited on what you can carry. So then, therefore, they're only selling you what's legal for you to walk out the door with.
They get a warning.
Each time you walk in the door.
Okay. Is there like a reason for that number?
We'd have to ask Chip and Frank.
Yeah.
Deb, do you have any idea how they came up with the 3 ounces?
Deb, you were around at the beginning. From what I've heard, the 3 was what I guess the assumed. We didn't know as much as we know now. Monthly needs for a cancer patient as much as 3 ounces. That's what the thinking was. That's what I was always told.
Okay.
That's what. Okay.
More.
Again, Lawrence, we know a lot more now than we knew then. But that's what, when it happened, that's what people were saying. Why it was 3 ounces, so cancer patients could go get a month's worth at a time. That was the reason for the 3. If somebody that was around longer can tell me different, please do.
I'm gonna hit up Chip.
But I just think, yeah, Chip was supposed to be with us tonight, but he's sick, so he wasn't able to make it.
I won't bother him.
Deb, step in here, please, if you don't mind, and tell us what you think about this.
Well, like you said, the technology's come a long way. The 3 was what estimated that a patient would need and might need in a month. But and Chip would know more about this, really, how they settled on that number exactly. I kind of thought it came through the legislature when the actual number came. 788 might have set that. I don't recall it setting that limit though.
Yeah, it did.
But it needs to be higher.
So do you think maybe in your opinion, we should be reevaluating all these numbers?
Yes. Sorry.
You think so too, Deb?
No, you're good. You're good. I agree. Definitely. And especially people that go by flower and they make their own medicine. You need to be able to get a bulk price.
Okay.
Because it doesn't make sense.
big
You got one person that can grow a bunch of flower over here and they're not limited. And you got somebody who can purchase flower and they are limited.
Okay.
I don't
So, all right.
Yeah.
This does, if I'm not mistaken, Lawrence,
Or carry.
I'll ask you to step in here. This does eliminate that 3 ounce limit though, doesn't it? This would eliminate that. Right now we have the 3 ounce limit you're allowed to carry.
Gets rid of that.
This doesn't give a distinctive amount you're allowed to carry in your possession. So it's just how much you're allowed to have is how much you're allowed to carry. So it's the 8 ounces, or
makes
as
sense.
Lawrence has said, whatever you grow. Is that
So I'm looking at Jackie. It could be an issue if you're a caregiver growing for someone and trying to get their product. So Jackie, the petition allows for, if you're growing, there's no limit whatsoever. You could have 8,000 pounds. So there's absolutely no limit whatsoever. There's no restriction at all.
I would say this. This is important. I would say this, that if you're going to do that, if you're going to carry a lot with you, and even if you're going to grow a lot, I suggest that you keep the stalk and maybe part of the root ball just a few inches, so that if you ever do get into trouble, you'll be able to prove you grew that. They'll have to do a lab test, but
Wow.
you'll be able to prove that you actually grew all that. So if you do get caught hauling 5 pounds to the processor, you can say, I grew it, and have the stock to prove it. So I
Yeah,
suggest
we might actually have to do a lesson on that and make sure we get, parts of the plant to have the proper hormones to even do the testing with, to be able to identify it properly together. Anyway.
Well, that's how they do it in other states that allow this sort of situation. But we managed to get this in there without that caveat. But I'm just warned every time it's brought up, I try like a disclaimer. I like to bring it up and tell everybody, keep the stock. So
Wild.
I don't want to see
That's
anybody get
interesting.
in trouble. So Lawrence, go ahead. Back to where you were at.
Right. So now, so the idea basically is that if you are a home grower, you're allowed up to 12 plants, and whatever you produce out of those 12 plants, it's legal for you to have, to possess, to transport, to have processed for you, and so on. So if you generate 30 pounds out of those 12 plants, then you could do whatever you want with them.
Yeah.
Now, to limit it to 8 ounces of store purchased cannabis or gifted cannabis, I wonder, something that was brought up was, if you're buying a pound at a time, you can get a steeper discount than if you're buying a half pound at a time. And I see there the argument for going from a half pound to a pound. So my only thought is this, that once you say a pound of cannabis, that just becomes a target for the opposition. You're allowed to purchase an entire pound of cannabis. So the 8 ounces is exactly what we have right now. And I just feel like that makes it more innocuous. So it's just a political issue. Like, I really understand that, frankly, there should be no limit, right? People should be allowed to purchase whatever they want, especially since they can have an unlimited amount at home anyhow. But then it just becomes a political calculation. So in a sense, it's sort of within Jed's purview there, right? Politically speaking, would we be at risk of losing any votes if we bump that 8 ounces up to a pound? But I think that's the only reason to keep it at 8 ounces versus a pound.
Okay, well, I think for the sake of the patients, it should go up. As we said, it was Samantha who brought it up on Sunday. Buying a pound at a time could save me $1 to $4, as much as $400 or $500 right there on that one purchase. So it could make a huge difference. I understand the political balance there on the trade for ounces for votes. I just wonder with maybe maybe we need to take a better look at what other states are doing and talk more about what the federal government is looking at, and seeing because if we're going to put this in the Constitution, I don't want us to end up with a low number when everybody is set the table. Okay, when everybody is set the table, when the federal government has changed, when all the states around us have done something, I don't want us to be high taxes and low possession limits. I want us to be attractive. So maybe we need to look at that.
The language on that, the language says a couple important things. It says that whatever the federal government allows, right, that we can change what we have based on that. So the language says that we can't have anything more restrictive than what the federal government allows. So if the federal government allows people to possess 10 pounds, then the constitutional language would then mean that we would have to bump ourselves up to 10 pounds as well. It also says that the legislature can come in and raise these amounts. So they're not set in stone. There's two different ways they're not set in stone.
Okay, well, There's a lot of places in here where it gives a little bit of control to the legislator to raise a few things or lower a few things. I don't think we should ever assume that's going to work in our favor. So I just see those as almost wasted ink. You know,
Let me see what Robin Selick says. He has a serious question. From a patient standpoint, how many patients can really go into a dispensary and buy 3 zips at once? What is a zip?
I think that's
Now,
an ounce. Yeah, I heard that recently too. I had to learn what that was about a month ago. So yeah, no, Robin, I understand that's a lot of money, but sometimes from a patient standpoint, that may be the way that I have to buy it. I mean, you know, some people may tax return or monthly check or whatever reason they buy several months worth at a time. If they can go in there and say, you know, they're buying it for a couple hundred an ounce, now they're looking at saving a lot and maybe dropping that price down to 100 an ounce or so if they buy a pound at a time. You know, now they're looking at a big discount. So I understand what you're saying. It's a lot of money, but
yeah, no, it happens all the time.
yeah, and
So here's the political
listen,
calculation.
And if you're gonna make a lot of RSO for yourself or something like that, or if you're a caregiver, in that case, you can make a lot of that. You're gonna need to buy a lot, and those people are just going back to the dispensary multiple times anyway. They're getting what they want. As I
Shake
said,
it flour. There's $40 ounces of shake, and you know,
as I said
I've
before,
had homeless people come in and
Hold on,
they have to transport it.
hold on, Raymond. As I said before, there's no limit on how much a dispensary can sell you in a day, just a limit on how much they'll sell you at a time, because there's a limit currently on how much you can carry out the door at the 3 ounces. So you're right, it would be expensive, but it's certainly how, if I have to buy it, that's how I'm going to do it. I grow my own, but if I have to go into a dispensary, I'm going to want to cut a deal.
Yeah.
Go ahead, Lawrence.
So let me just sort of say this. We have 16 viewers right now. Wonderful. Thank you all for joining us. I kind of feel like we should have 100, 200 viewers, because if this moves forward, this is going to affect everybody in the cannabis community. And given that, you know, Chip is involved, we're involved, Jed's involved, Ron Durbin's involved, given that everybody who's really involved in legislation and in trying to shape this program are playing a role in ORCA, we want the community, right, to be participating. And I wonder maybe what we should have is, you know, tomorrow there is that protest against OMA at the Capitol. Maybe what we should have is something constructive too. Maybe we should have a physical sit down where people sit down and hash out some of these issues too, right? I just wonder, you know, because face-to-face meetings sometimes could achieve things that online maybe not. But
So you mean
Jed's
hold
planning,
on. So are you talking about like community gatherings to discuss these petitions in person?
yeah, because if Jed is planning on filing this stuff in the next couple of weeks, all these people who will be affected by it, right, you know, need more advertising of the fact that there is this discussion going on, rather than being blindsided by it once it's filed. So, you know, people who have ideas, I see Chance agreeing with me. You know, the protest tomorrow, it's, you know, legislature is not in session, right? They're not there. And it's a way for the people to get together to express their feelings. But I kind of feel like we really should have a town hall meeting related to the positive side of all this, what we now practically and positively could do to improve, to control our own fates and improve our situation. So Chance, you know, talk about this with Jed. And, you know, Chance is mentioning that there's a lot of conversations going on beyond the Facebook bubble. That's absolutely true as well. But you know, the Facebook bubble is an important bubble. And, you know, I just really want there to be more community involvement in all of this. Sorry, that was just a little side issue, but I just think that we really need more engagement. Shall I move on with the petition?
Yeah, go back.
Okay. So, general protection language. So, what's done here basically is it gives sort of the general broad scope personal protection, and then it goes into the details of that in the subsequent sections. So there's sort of catch-all language, and then it drills down. No person shall be subject to arrest, prosecution, or penalty in any manner under any state or municipal or county ordinance or resolution, including without limit, civil penalty or disciplinary action by a business, etc., solely on the basis of conduct permitted under this article. So that basically what that means is that whatever you're doing pertaining to cannabis that's made lawful by this constitutional measure, then nobody should get into any kind of trouble whatsoever. All right, just broad catch-all language to start out. No person shall be denied anything. They shall not be denied health care. They should not be denied housing. They should not be denied employment, public assistance, etc. Nobody should be denied anything based upon the conduct permitted under this article, with that one qualification, unless failure to do so would cause imminent harm under federal law. So your employer says to you, I have these government contracts, I can't let you do it. Then you have a conversation. If I do it, how is that going to mean substantial and imminent harm to you? Like employers will use this as an excuse, right? They'll say, oh, gee, we have federal contracts, we can't let people use cannabis. Well, that's just really, hope you don't mind my saying it, bullshit. Bullshit. Because the Federal Drug-Free Workplace Act does not mandate that nobody under the employment of that business can use cannabis. It doesn't. It doesn't. So it's just an excuse. And so unless you're like a naval pilot, or unless you're doing something that can be directly correlated to what the government demands of you and so on and so forth, then you should be able to conduct, engage with cannabis regardless of your employment. And Chance says, maybe we should have create other events and video town hall. Yeah, we could talk more about other options. Let me move on. So basically this says nobody should get into any trouble. Nobody should be denied anything. And now more specifically, nobody should be denied any public benefits. And now no test which identifies the presence of THC metabolites in a person's body shall be used as a basis for claiming impairment, because THC metabolites stick around in your system for weeks and months, right? So they shouldn't use THC metabolites as a basis for claiming impairment. They can use active THC, the active THC molecule, to evaluate impairment, but not the THC metabolite. So those are the general
Hold on, Lawrence. Let me interrupt you for a second to get into something specific. I want to open it up to Raymond for a second. Raymond, you had talked about something you wanted to bring up. I think this is where you're going to get those answers. So why don't you ask the questions?
Yeah, I think Lawrence probably has. Sorry.
I know what you're going to ask, Raymond.
Well,
let's hold off until we get to the parental rights issues.
Okay. Yes, absolutely. Yeah. So, and I'd like to, more about that. You have some actual information that I don't have on that. So, but I would love to bring that up for sure. Don't let me forget.
Yeah, when we get to that section, we will. Sorry, Chris. I know what he's going to ask.
Okay, I know you do. I just want to give him the chance to ask the question so everybody else can hear it.
Yeah, we'll get to it in just a moment. So like I said, that catch-all section, general protections, basically nobody gets into any trouble, nobody could be denied anything, and you can't use THC metabolites as the basis for impairment, right? Now we start drilling down.
Hold on a sec. Deb, what do you think so far? You're kind of quiet there. Let's get a little something out of you.
I don't like the word metabolites being included with THC. I think THC testing for impairment, whether it's metabolites or whether you're calling it the active or whatever, I'd like to see no THC testing for patients.
Okay,
We
Lawrence.
have to do metabolites. Yes.
Okay, Lawrence, why don't you explain the difference in the metabolites and what this does?
So when you consume cannabis, it gets converted by your liver into what are called metabolites. It gets, your metabolic system converts it into other molecules. Some of those other molecules stick around for months, right? And so employment screening, drug tests, for example, related to parole or probation, drug tests for patients going in for pain management, parents wanting to test their kids, just about all of that is not testing THC, it's testing a metabolite. And we're putting into law saying, let's not get our science wrong here. If you have a metabolite in your system, that means nothing with respect to your impairment. So that's all about correcting the science. We're saying, if you want to test people for metabolites, we can't legally stop you from doing it. What we can do is you can't use it as the basis for asserting impairment, which means that in the workplace, they can't claim that you're impaired, right? If you're at a school and it's about an extracurricular activity or whatever, they can't claim that you're impaired.
Okay,
And
hold on.
so it's
Hold on, Lawrence. Now, if you don't mind, explain the active metabolites and why they still won't be able to test for those and determining impairment.
so if there is some cause for evaluating impairment, let's say a workplace accident. So let's say, you're at some kind of, company that cuts stuff or whatever, and there's sharp, dangerous equipment, and somebody has an injury, and they want to find out whether or not the person running the machine was impaired. And they ask that person to provide a urine sample. And then they find in that urine a THC metabolite. That will mean nothing by law, according to this. But if they want to find out if you're actually impaired, then one data point, not all the data points, but one data point that they can use is with a blood test, find out if you actually have the active unmetabolized THC molecule in your blood.
Now, that would mean that you've just recently consumed, right?
What's the
Right.
time frame? Do we know the time frame?
Yeah, so a couple hours, basically. It depends on whether you're consuming orally or smoking, but sort of realistically, 2 to 4 hours, all the active THC should have been metabolized within around that range.
So
Okay.
how does that sound, Deb? I understand the desire to just eliminate THC testing altogether, but that's impossible. This at least makes it where the science has to match. What it does is it also encourages companies to do more of a cognitive test. So it will encourage them to develop more cognitive test apps and things like that, because they can do all that. When you go to clock in with a couple of minutes on an iPad, you could take a little test to determine whether or not you're impaired and can or can't do your job. But at least this eliminates what we all know is the killer for every cannabis user, that you're going to test for dirty for what could be a few months, and
Yeah.
you're not going to get, or you're going to lose that job. It at least takes care of that. What do you think?
Well, it's better than what we have, but I still don't believe that presence of THC, active THC, is indicative of impairment. I just don't think the science supports that. I think there's science to show that it's active and not metabolized, but
I have to
and
agree
I
with Deb on
don't
this
know
one.
that. Huh?
I agree with Deb 100% on this one. I like maybe impairment on a new user, but not impairment for someone like me and Deb and you, Chris,
But,
and maybe more.
Let's say, all right, if we acknowledge that you're right about that, like you just said, Raymond, maybe on a new user. Okay, so therefore we're acknowledging then that it's going to affect everybody differently. So why would we want to allow a bunch of people who can't handle it to be high at work
For that.
because a few of us could handle it? That
Yeah.
might be a really dangerous mistake. What do you think?
Yeah. Yeah, I agree. And I actually really enjoyed your comment on like the field sobriety work test, basically.
Yeah, well, it's
Uh,
something Lawrence has told me about, where they have those things. They use them in
I could pass that.
they use them in certain industry already. Look, I can tell you that we watched, Norman and I went to Muskogee and watched a DUI test, a driving test that was done here. And it was a texter, a drinker. Well, it was a few texters, a few drinkers, and a few smokers. And of course, the texters were out within a few minutes. You can't text and drive, don't do it. The drinkers, well, you know, they thought they could drive long after they were running over cones. They still thought they were good enough to drive and wanted to keep going. But it was kind of funny. But the cannabis users were driving until the instructors got tired and quit. By the end of the day, they were looking for any reason they could to even notice that somebody had or had not used, like laughing. I mean, it was that bad. They couldn't figure out anything. So it was kind of funny. But Lawrence, you want to throw us some science here, maybe?
Yeah.
So, yeah, when it comes to the correlation between metabolites and impairment, they're basically, when we're talking about the secondary metabolites, the ones that are usually tested for, there is absolutely zilcho correlation. There might even be a negative correlation. But when it comes to active THC, then absolutely there's a correlation between impairment, because the people who don't get impaired by THC are the exception, right?
Right.
Most people don't use cannabis on a regular basis. They don't use it every day. And so, 5 to 10 milligrams of THC will be impairing for probably about 90% of the people who have patient cards.
See, and
All right, let's move on. Go ahead, Lawrence. Let's move on. We'll get to that part where Raymond gets his question.
Okay, so the next section that we're sort of drilling into, privacy rights. It's been on the screen for a while, so some of you probably have already glanced over it. Basically, what it says is that patients will have HIPAA level protection with regards to anything related to cannabis, with respect to the regulatory agency records, with respect to business records. It's all protected. So that's pretty straightforward, I guess. Employment rights. So this is stronger than what we have now. No employer may refuse to hire or discipline or discharge or otherwise penalize an applicant or employee solely on the basis of conduct permitted by this article. No employer, including safety sensitive, no employer can deny you on the basis of conduct permitted in this article. So if you are an airline pilot, if you are a surgeon, you could still get a patient card and consume cannabis outside of your work. All right. Number 2, this is not to exclude workplace policies which prohibit the use or being under the influence of marijuana during a work shift for a safety sensitive employee, or the testing for active THC in order to assess current employment, and standardized kinetic and or cognitive evaluations to determine job safety and current impairment of personnel shall be permissible to determine impairment. So what that basically is saying is that if you are a police officer, if you are a truck driver, an airline pilot, a surgeon, whatever, you will be legally permitted to use cannabis. After all, you're legally permitted to use opioids, right? You're legally permitted to drink alcohol. You're legally permitted to do anything under the sun that's impaired, barring federal law, that's impairing you, right? You just can't be impaired at work. Just like with alcohol, just like with opioids, right? So that's what this is saying here. And that applies across the board, safety sensitive included.
And let me interrupt for a second. For those that are going to ask why we can't put in there that you can smoke at work, because I still get people writing me that on a pretty regular basis. There's no way anything like that would ever work. You just can't do that. Go ahead, Lawrence.
I think we could, but we get such pushback. I
Well,
think
that's
it would
what,
hurt the
that's what I
petition.
mean by you can't. If we were to do that, then the people would come out of the woodwork to vote against this. People that never voted before would suddenly register.
If
I
we
mean,
say that employers are required to accommodate the consumption of cannabis in the workplace.
yeah,
Yeah.
it's not
Right.
it's not breastfeeding. We're not going to be able to get that through. It just wouldn't work. It would not work.
Yeah.
People aren't going to be enough people are not going to be okay with that.
We'd lose a lot of votes, I assume, if you made it a matter of law to require employers to accommodate the consumption of marijuana at work.
Same with consuming marijuana. Same with consuming while you're driving down the road. That's another one that people request pretty regular. They somehow want it in here where you'll be able to smoke and drive.
Yeah.
Cannabis affects everybody differently. We can't, if it's too many people do get high, we can't just let everybody make it legal for everybody to drive down the road smoking.
Here's the thing, people could still take an edible, right? And your employer will never know or may never know, right? So if you want to, find a way to consume cannabis at work, if you rely upon cannabis to deal with ADHD or whatever it might be, and you're a better worker as the result, well, while you're at work, edibles. There's still ways you can get around it.
And where there's a will, there's a way.
Yeah.
But then you're going to have that active THC. You would test positive
Right.
for active THC.
Right.
That's
Right. Well, like Lawrence was saying, if you're better at your job, if you need it that bad, you will find a way.
It's not, so, right.
Certainly not.
So a workplace
encourage
can
it, though.
prohibit being under the influence in a safety sensitive job, right? They can still prohibit it, but it's up to you and your employer, because, I might say to my employer, look, I've been working here for 20 years, and something you don't know is that I use cannabis every day, and I'm your best employee. And why? Because I have ADHD, and cannabis helps me with that. And you have that conversation with your employer, and your employer might be fine with your use, right? So the idea here is employers are given flexibility, but patients are given protections, and hopefully that combination will generate the appropriate conversations. Okay, healthcare rights. For the purposes of medical care, this is language right out to 788. For the purposes of medical care, including organ transplants, marijuana use does not constitute the use of an illicit substance or otherwise disqualify marijuana users from medical care. So this starts getting into the issue that you're wondering about, Raymond. What it basically says is that marijuana use does not constitute the use of an illicit substance, right?
Yeah.
So we'll get to the employee, we'll get to the parental issue in a moment, but that's a piece of it.
Yeah.
No
That's
medical
one,
practitioner.
That's
Sorry?
one of definitely a list of things, that anything that you could be drug tested for, but in particular, yes, mothers and their babies' first diaper, I think, is what they're testing. So,
Yes.
things like that.
And this is current law too, by the way. Number one
Okay.
is current law.
Gotcha.
Next, no medical practitioner should deny or alter the treatment of a patient, including the prescribing of scheduled medications such as opioids or benzodiazepines, solely on the basis of conduct permitted by this article, unless that denial or alteration is medically indicated. So since 788, pain management patients are being regularly terminated by their doctors for using cannabis. So the doctors will terminate you or will stop prescribing medications. Pain management, psychiatry, oncology, the doctors will say one or the other. You can continue on letting me prescribe these things to you, or you can use cannabis, but not both.
Yes.
And this is now putting it into the Constitution, saying that it is unconstitutional for a doctor to deny your treatment solely because you're using cannabis, unless he can come up with a good medical reason. Here's a research article showing me that given your medical condition, I can't prescribe this while you're using cannabis. Absent clear medical proof, it will be unconstitutional for a doctor to deny prescribing you.
Okay.
All right.
That is exactly the type of things that don't need to be looked over for sure. And I was wanting to ask you, would it be a federal issue, you know, like the VA and housing? Or they drug tests there?
So those are separate issues. Let's
Okay.
so the
Yeah.
housing one, the housing one, I guess we've already covered up here. And so the housing one is here's the current law. At the federal level, the federal policy is that it is up to the discretion of the local housing authority to set their policy with regards to permitting cannabis.
Okay.
At the state level here in Oklahoma, the law is that no federal agency can deny a benefit to a cannabis user unless federal law demands that they do so. So as it is right now in law, a local housing authority must allow people to use cannabis. If they don't, they're violating federal law. But, nobody is acting on that. Nobody is challenging it.
Gotcha.
Okay. So the next thing here, this kind of number 3 beefs up number 2 by defining standard of care. So it's number 3 beefs up number 2. Parental rights. Now we get to the issue that Raymond has. Raymond, you mentioned that there's been a few news stories recently about pregnant women being charged with child endangerment in virtue of their use of cannabis, right?
Yes, and I think there's I don't think I have all the information that you have, but yeah.
He didn't mention the stories. I mentioned the stories, but it was after he called me and said he wanted to bring this subject up tonight because I had heard about this last month. This happening. Go ahead.
So what this basically says is no person shall be denied custody or custody of or visitation or parenting time with a minor, and there is no presumption of neglect or child endangerment for conduct permitted under this article. So somebody who's consuming cannabis in accordance with what the law allows, there is no presumption of neglect or endangerment. So what does that mean?
So had this been passed, they wouldn't have been able to charge them with endangerment because that's what they were charged with.
Right.
Okay.
And so current law is, just hang on one moment here. I'll tell you what current law says. Current law is there is no presumption of neglect or child endangerment for conduct allowed under this article unless the behavior of the person creates an unreasonable danger to the safety of the minor child. So current law also says there is no presumption of neglect or child endangerment, with the caveat unless the behavior creates an unreasonable danger to the safety of the minor child. So, this is a little more absolute. But
that's
somebody
open
is
for interpretation, really.
Yeah.
Yeah, and so the question is cannabis use during pregnancy, is that something that endangers a child? And so if you go through the medical research, I think the simple answer is it's up in the air. There's evidence in one direction, there's evidence in the other direction. It's up in the air.
I thought we were going to have a very different discussion because I would like to see any information that proves otherwise. And I would not doubt that carbon inhalation of a burnt substance is the issue there. But I definitely think that there are benefits and things like that for a pregnant mother. And if that's your primary medication, I definitely don't recommend transitioning while you're pregnant on any type of medication. Up to your doctor. This is a doctor conversation for sure. I'm not a doctor, but I've heard.
Yeah, here we have it in the comments from Rachel Dipple that she says that she had a DHS worker show up unannounced. That she's a card holder and consumed while pregnant. They found THC in the umbilical cord. And that's what prompted this home visit, like why, she says. So, right, so current law basically says this, that for medical purposes, cannabis shall not be construed as an illicit substance. And it says there is no presumption of neglect or child endangerment. Okay, so given those two things, it's not reasonable for any pregnant woman or woman who's recently given birth to be criminally charged, right, for the use of cannabis during pregnancy.
Yes.
It is, and if this gets to court, they should be able to win. So the issue is this: if you go through all the medical research, and I've read a couple dozen research articles on this, there is no evidence to show that use during pregnancy increases the risk of any kind of cognitive deficiency, as the person develops. There is a little bit of data to suggest that there is some increase of risk of ADHD, but it's really minor. And there's all these comorbidities. You don't know if those are relevant. Lower birth weight. There's a little bit of evidence in that direction, but again, it's minor and there's lots of comorbidities. But when you look at the meta-analyses overall, the data to suggest that there's any significant risk is very, very weak. Very, very weak. So I think that it's still an unknown, because consider this: cannabis is powerful, THC is powerful, the brain is developing, and if you significantly upregulate some activity, right, some metabolic activity, and significantly downregulate other metabolic activity through the use of cannabis, the effects on the developing brain will be different than the effects on the developed brain. Yeah. And as a little side note, that THC does interfere with folic acid, with the absorption of folic acid. So it's not the THC itself that's necessarily the problem, but THC does interfere with the absorption of folic acid, which basically means that a woman who's consuming cannabis while pregnant might have to be more careful about their folic acid intake, right? So there are some issues, but again, it's not like THC consumption during pregnancy is a major physiological risk.
Yeah, that's some great information there. I'm fascinated with that.
Okay, so
new information.
Let's keep in mind what we got out of that was they can still charge you, but if you hire a good enough lawyer, you should be able to get it dismissed.
Yeah.
I like where the new language is going, though.
Yeah. And Rachel says that studies also show that it helps with nausea and general pains associated with pregnancy. Absolutely. Like, one of the best established benefits from cannabis is its antiemetic effect. And so a woman who's having a lot of morning sickness, a lot of nausea, what are her options? She'll have to go to a prescription medication or cannabis to deal with that nausea, because the persistent nausea creates risk for the fetus. You're nauseous, so you don't eat, low caloric intake. That low caloric intake could have much more serious harms to the fetus than the cannabis. So if you can mitigate the nausea through cannabis, then that might be of significant health benefit to the fetus. And basically what you need, as I see it, is a woman who's pregnant who wants to use cannabis has to have that conversation with their OBGYN, and they have to find an OBGYN that is properly trained with respect to the endocannabinoid system. Because just let science figure these things out, not stupid district attorneys who don't know any better.
Okay, let's move on and wrap up this this section here.
All right. So licensure rights, I'm going to really quickly go over it. Basically, whatever licenses you have of any sort, driver's licenses or anything else, you can't be denied them or lose them solely on the basis of using cannabis. Second Amendment rights, same issue, full protections for gun ownership. Fourth and Fifth Amendment rights. Now, here's a really important one, right? Something that, by the way, we don't have in law right now. That was there in 806 and 807. We don't have in current law. It is really, I think, one of the most important things. What it says is that the use of cannabis, the appearance or smell of cannabis cannot be the basis for a law enforcement officer to detain you or search you or search your person or your vehicle or your home. They can't conduct a search based upon cannabis. Right now they can. We need to stop it. We need to stop it.
That has to do. That has to do. Let's tell everybody that has to do with that recent court decision where they used the smell of cannabis or the possession. They saw half a joint, I think it was, to search him, the person, his car, and his hotel, which would be your living
Right.
quarters. So
Right.
he was arrested for a whole bunch of other crimes. Now I understand some of those were bad, and I'm not saying he should have been doing those. The cannabis never should have been what opened the door, because now every time I drive down the street, I have to worry what else might be in my car I'm unaware of, or what else are they going to throw at me if they now see a joint, So
And I hate to say it, but I think this is one of the absolute biggest oversights with 788, that they didn't provide any Fourth and Fifth Amendment protections. And we really need them. We really, really need them.
yeah.
And similarly, do we say, does anybody still go to jail for cannabis? Yes, specifically people who get their bail, parole, or probation revoked. So you're out on parole and you use cannabis and they urine test you and you go back into jail. And so this basically this will prevent a person from returning to jail, having their parole or probation or bail revoked for the use of cannabis. Another really important thing that needs to be fixed.
Okay. Lawrence, we're already running up on an hour, so I'm going to change it up here just a bit. Can you wrap up this section real quick? Okay, that was a little quicker than I expected, but that's pretty quick. Deb, let's touch base with you for a second. You said the least here. I'd like to hear a little bit out of you. Is there anything so far you've heard that is disturbing? And is there anything you can think of that maybe is missing that Lawrence could address that maybe we didn't cross over yet?
Sorry, this kind of blinked in and out, but I'm back. The one thing when we were talking about doctors, and we're telling them all the things that the doctors have to do, or give them permission to do. I don't know. I'd just like to know what y'all guys thought. If there's a place here to put that a doctor can't be sued for malpractice over cannabis recommendation.
Yeah,
I mean,
that's interesting.
we have no
Okay, so-
malpractice apps in Oklahoma. Doctors are scared to death anyway. We've been bleeding doctors since the early 2000s when the surrounding states put in malpractice caps. And I think if we just gave them a little something like, we're not going to sue you over this. You can't be sued in Oklahoma.
Okay, I think this does. Lawrence, you want to address that?
Yeah, actually, one of the contributions that I made to 2612 was exactly this issue. To have very, very broad, very, very strong language to protect doctors from any kind of criminal charges, civil litigation, loss of licensure, any kind of risks whatsoever for either recommending cannabis or for treating patients who use cannabis, including treating them with scheduled medications. So, this was central among my goals, to put into law that no doctor whatsoever would ever get into any trouble for either recommending or treating patients who use cannabis. And so, a doctor right now, by law, they can prescribe opioids, right? They can prescribe opioids to somebody with a patient card, even though 85% of the doctors in the pain management won't. But we have that legal protection at the state level. And one of the things that I did in the language here was I refined it somewhat so that there's something called the locality rule. It gets into some details here, but I refined it in such a way that it will then work at the federal level too. Even though we're only writing at the state level, the language that I put in there will actually carry over so that if a federal prosecutor tried to prosecute a doctor in the state of Oklahoma, they're going to have to evaluate the case based on state law. That's called the locality rule. A lot of detail, but it means basically that doctors will not get into any trouble.
Nice.
Hey, Deb, what do you think there? Sounds like he's got that one covered as of 2612.
That sounds great. Doctors don't seem to realize this, so
Yeah,
good to know.
I think maybe the problem is we're still not getting enough participation. And I know one thing we tried to work on this last session was getting some language into an opioid bill that was similar to this. In fact, that was how we tried to sell it. Was it's already in 2612 in cannabis law, but we need to put it in opioid law because that's what the office manager is going to look at when setting office policy, or the doctor is going to look at when setting office policy. So that would get it in front of them. So we've got the law already taken care of. We're just not getting the right people to look at it. Again, we tried to get that fixed. Lawrence, you could give a little update on the opioid thing, maybe.
Yeah, I actually have a meeting with the governor next week on this.
What's that?
And I have a meeting with the governor next week on this. On basically, and so next week, myself and some of the other people that worked on Senate Bill 57 meet with the governor to talk about basically pain management issues in the state. And this marijuana thing, I don't know if it'll come up in the conversation, but I'm hoping that it does. But as well as that, we also got approved by the legislature an interim study on issues having to do with pain management, where I've been asked to speak, and I'll also be talking about this issue.
So that's you're right, Deb. We don't have enough doctor participation. We are losing doctors. I myself lost my doctor the week after I got my card. So it's a problem, and there's everybody doing everything they can from every direction to try and deal with that one for sure. For sure.
Right after 788 passed, I met with a licensure board about this, and I met with a pain society. I developed a really good relationship with the director of the pain society. I got the pain society to issue a policy statement that supported cannabis. And so, you know, everything at the state level is, you know, it's being pushed all the way since, you know, the dawning of 788. It's just that there are a lot of doctors out there who are so risk averse that even though everything is being put into motion to give them the protections they want, they're just too afraid for good reason. The DEA is insane, right? The DEA is like, you know, the Nazi SS.
Yeah. I think that was some of the biggest things that we had conversations over, because I, you know, had my opinion that these opinions aren't going to change until federal, you know, rolls around. But with this language that you're putting in there, you know, it's definitely looking better and better.
This at least moves it to the Constitution. You know, as he was saying, it's pretty much statutory already, but that isn't enough teeth to get him to pay attention to it, I guess. And of course, we'll continue to push next year for it to go into more language that will go in front of the doctors.
Yeah. Yeah. And,
That's a great
part
point,
of it
Dan.
also. Yeah. And part of it also is that, you know, it's my own education too. I'm not an attorney, so I have to learn things along the way. And by writing it in the language of standard of care is formulating it in such a way that will allow basically local doctors to fend off federal agents.
Okay, well, like I was saying, we're running a little bit long. We've already gone over an hour, so I don't want to keep going over these petitions line by line. I do want to bring everybody back, not that we're done yet, but I want to bring everybody back to do it some more. And in fact, I want to do this at least twice a week with anybody willing to sit here and talk about it, because as we were saying earlier, there doesn't seem to be enough understanding of what's in here. I do want to, Deb and Raymond, I want to ask you guys, does it sound to you in general, and I want you to go and look at this language, but does it sound to you like we're, like at least the patient protections are getting done right? Does it sound like this is working out pretty well? What do you think so far, Deb?
I think we're headed in the right direction. It looks good to me.
Okay. And Raymond, what about you?
Yeah, with the patient protections part of it, yeah, I like all of that. I think that is the necessary thing to be talking about right now.
Okay. And about how many pages is that, Lawrence? The patient part.
The patient part itself, just the patient part, somewhere between 3 and 4 pages.
Okay, so we've only gone through 3 or 4 pages roughly of what, 22?
Somewhere around there.
Okay,
Yeah.
now that will shrink some. I understand there's not 17 pages of regulation once it's written differently, once it's condensed. But currently it's quite a few. So it's going to take quite a while to get through all of that. So rather than doing that on here, I'm going to ask you guys to go and look at that and ask everybody else to go and read some of those regulations. If you saw the show last night, you see I have some serious concerns about them. If you didn't, I'll tell you, I have some serious concerns about it. I have real concerns about all that regulation and the details of what it is going in the Constitution. I agree with what you guys have said. The patient stuff sounds like it's getting hammered out pretty well. I'm not sure what's missing. If something is, I hope someone can step up and tell us what quickly. Because again, he's moving forward. Jed is moving forward with these. And I understand there's a world besides Facebook where people are talking about this, but I can't imagine it passing in Oklahoma if it wasn't at least talked about on Facebook. And I'm not seeing that. I'm really not seeing that. I've seen Chip talk about it a little bit on his show. We've talked about it for a couple of weeks now, but I'm not seeing posts with sections of it and people commenting. I'm not seeing DC or any of these other people that do their lives talking about it. This guy read every single line on 806 and told us how Canada was going to come take over the state. Where is he? Where is everybody in relation to this petition? Or is everybody just okay with whatever passes? I'm seriously wondering, is everybody just last year they didn't want nothing. This year it doesn't matter. Is it just me? Deb, do you feel at all like that, or is it just me?
No, I think people get excited and about a few specific issues and kind of get waylaid. Right now is the time to be developing, what we're talking about now and legislation for next year. And I'm not seeing those conversations.
And this petition is 3 weeks into a 4-week public comment period. So
Yeah, people want to wait till the last second, I imagine.
if it's okay, but if it stays, what's the last second? Are they gonna wait till the day after he gets them all printed?
Yeah, I don't understand it either. Procrastinators.
Day after it's filed when we can't change it anymore? Go ahead, Lawrence.
Yeah, let me interject that there are comments coming in that I'm sent, a couple pages of comments, a couple times a week. So it's not like, it's like inundated by it, but there's sort of like these little clusters of comments that Jed receives and sends it around to the working group. And so they are coming in from the website. As well as that, I posted this stuff on Reddit 4 or 5 days ago, and there's a lot of comments from the Redditors. So they're more involved than Facebook. And I think part of it has to do with the politics of Facebook, right? That it's much more cliquish, and that there's a history on Facebook about how people went nuts over 806 and 807. And it's like, well, if they now love ORCA and they hated 806 and 807, how do they reconcile those two? Is it just because, and I know there are differences. I completely agree. There are differences and there are problems with 806 and 807, but it's not a matter of looking at this, just calling it 806 and we didn't like it, and calling this ORCA and we do like it. The devil's in the details. The details matter. The details matter. And the problem that existed with 806 and 807, that has been addressed, in the ORCA petition. So that's obviously very important, but I don't know if people would be able to even name what those problems are. But there were actual concrete substantive policy problems in 806 and 806 that were recognized and fixed for this petition. But we should have public conversation about these things, because there may be problems in the ORCA petitions that we didn't spot. When I read 806 and 807, it took me a couple days to catch the problem with those petitions, because it wasn't in the words, it was in what wasn't in the words. that was the problem. So, the more eyes on this coming at it from different perspectives could make the difference between this passing and not passing, this saving somebody from major harm, and, them having trouble with the law or whatever, because we just didn't catch something. So, real serious reflection from different perspectives. I don't have the perspective of a cannabis user. I'm thinking about it in terms of social justice and medical autonomy. We need people from different perspectives looking at this and giving us substantive input.
And we need some of these business owners, some of these 7,000 license holders to comment on some of the regulation. And if that's right, I mean, I don't think it all belongs in the Constitution, but if it's going to go in there, I would hope that at least it's as right as it can be. And at least from what I understand, I don't think it is, but I don't, I disagree with things like putting the batch size as Jed and I went round and roundabout last night. I disagree with putting a 20-pound flower batch size in the Constitution. It just doesn't make sense. It seems like that should be, that's an organization thing. You create the organization and they create all those rules. Lawrence, let me mention this. I did, because I mentioned your name a couple times last night during the show, and you weren't on here to defend yourself. Not that I was saying anything derogatory. I wasn't. I was actually using you as my weapon. But let's. I want to address that a little bit. Problems that. One thing Jed and I kept bouncing heads about last night was me saying that I thought this could be more general language. It could be more broad. And I even said during that, and this is why I'm asking you to talk about it. I said, well, Lawrence has given many options on other ways to put those 17 pages of regulations to get that idea across without all the detail. Could you perhaps enlighten a little bit on some of the suggestions you've made?
So, of course, one option, which I don't think is satisfactory, but one option is to basically just say, there shall be a regulatory agency responsible for setting the rules with respect to all the conduct that's been authorized by this article. Done. That's it. One sentence.
I don't see why that
one
wouldn't work.
strategy. So it depends on what you want to accomplish. And the problem basically right now is that those 17 pages are written because they're trying to fix known problems, right? So those 17 pages aren't basically just sort of generic neutral language. Here's the agency. But those 17 pages are crafting an agency designed to fix problems seen with OMA right now. So the first suggestion, Raymond, the one that like if we were just sort of coming at this blind without knowing what the future holds, as if this was just our first introduction to cannabis, then we could just authorize it. That's basically what 788 did. But we now see problems in the way that OMA is running that need to be addressed. So the next option is to have language that addresses those problems. And one way of doing it is by virtue of the 17 pages, where we're kind of trying to target the specific problems and offer structural solutions. So here's an alternative. And I'm not discounting those 17 pages because they're good, right? They're well conceived. I like a lot of it. But if you want an alternative that's shorter, if you want to have an alternative out of principle saying we ought to be economical in what we add into the Constitution, the alternative, follow my reasoning here. It's kind of, maybe, I don't know if it's that complicated, but it's sort of subtle. What is the problem that we have with OMA right now? Maybe the biggest problem that we have with OMA right now is its top-down approach. And so let me explain it in the following context. Some of you know this, probably most of you know this, that I run a department at Oklahoma State University. I'm the director of the religious studies program there, right? So I administrate a program, and I have staff assistants, there's faculty under me. I write policy documents. I write workload policy documents and so on and so forth. I'm on various committees that do it. 20 something years of experience doing this. So I'm not coming at it from a person who doesn't understand government regulatory systems. So the issue is, as I see it, is when there's a policy document that needs to be written, the way I approach it in my leadership role is I'd say, okay, we've identified the need for a policy document. So what we do now is we have a meeting to discuss what our goals are with respect to that policy document. And then we start coming up with draft language. And then we reflect on that draft language. And we spend some time maybe away from the meeting to come up with further ideas, to sit on it for a while. Then we come back and revise that draft language. And we do so not by me as the director telling everybody, here's the new policy statement. I want all of you to vote on it. No, the way I do it is I'd say, here are our goals. Let's have these conversations. Let's get these other experts, right? These other people who are familiar with the needs of majors and minors and familiar with workload for teaching and research and all that stuff to offer input. And we craft it as a community. So what I felt was lacking with OMA, especially at that most recent, the Food Safety Board meeting, was there was no sense of communal crafting of rules. Director Williams came in and said, here it is, everybody. And then she got loads of feedback and basically sort of just politely said, we'll take it into consideration. But the rules that were written are the rules that become official. So she comes in with a completed document and the Food Safety Board is irrelevant, right? It's irrelevant. What we need is this. What we need is a director who says, here's what we have to do with regards to new rules. Here are our goals. Let's have a conversation and let's start drafting it together. You develop a draft. You spend some time exchanging ideas, reflecting, sitting on it. You reconvene, and it never finalized until you get a supermajority, 2/3, 3/4, all approving it. So rather than saying, here's the finished draft, let me see if you have any concerns. Thank you very much. Maybe we'll deal with those in the future, but here's the project that we've already finished behind the scenes that nobody had any say in until now. That's backwards. The Food and Safety Board and Advisory Board should be there crafting the rules.
Okay,
under
so
basically the administrative leadership.
I'm sorry to interrupt you, but how do you then put that in a petition that is shorter than the 17 pages?
Right. So I'm trying to explain, I'll answer the question. I'm trying to explain like the real life problematic here. Right? That's the real life problematic. You get it, right? How do you get the experts to write it? So what you do is you write it into a petition, things like the drafting of regulations shall involve the advisory board, right? That the regulations shall not be approved without 2/3 or 75% support from that advisory board. So you put it into the language that basically requires that the advisory board contributes to the drafting of it, not just that they approve the finished product, but they contribute to the drafting of it, and that the rules never become official until the advisory board supports it with a supermajority.
Okay, but then how do you determine, how does the industry keep control of, because this seems to be what they're trying to do, keep control of creating that advisory board? And I want to say something. Jed came back at me last night about the number of jobs I said this created. I want to say I was completely right on the number I said. They're just not all paid jobs. Some of them are volunteer. What are they called? They're just not called jobs. They're the advisory people. Each person has 5 underlings that advise them, and those are non-paid jobs that are going to have to be filled. So it was 56 positions being put in the Constitution, not all paid positions. but 56 jobs in this agency required by the Constitution. So there on that one.
Yeah, but yeah, how relevant those advisors are is open to whatever else you write into that. And the way OMA is right now, they're irrelevant, right? They're just there because 788 required that there's a food and safety board, and they're not being used, right? So all that expertise in the food safety board has no role, is not playing any role because of the top down, right, approach.
So you think if we
That's
just put it,
all.
so if you think if we just put in there, if it was just put in there that the advisory board has to give approval in the way that you've laid out, you think that would be enough, and you then don't need to also put how the agency is picked? Again, we haven't gotten to that. This requires people getting other people to sign a petition, basically for them to be on the board. You have to get votes, sort of, as would be a way to describe it, I guess. How do you leave all that out and make them still feel like the board isn't going to be rigged?
One of my thoughts is that almost all of this depends upon the goodwill of individuals. That, the most perfect system in the world could be corrupted if the people involved are corrupt people, right? So whatever you put on paper in terms of the rules, that's just, a tiniest little role with regards to the honest functioning of a system. And so it's not like there's any way we could truly stop corruption and abuses of power. It's not like there's a way in which you can write it down to guarantee, right, that everything will be done in an honest and upfront way.
I mean, we shouldn't start with a popularity contest, though. That's like the worst way.
Jed has changed it from 200 to 200 recommendations for the position to 50. So he has brought that down.
I'm viable now.
Deb Davis, petition policies, procedures, goals, desired structure, board should consist of people from various backgrounds. Deb, that's definitely right. And that is the way in which Jed has it crafted, that there's a certain number of seats related to processors, certain number of seats related to growers, and so on and so forth. And some of them get recommended by the governor, and some of them get recommended by the senator pro tem, and so on. And so there are all these different streams to hopefully break up the kind of sort of cliquish unity, right? As if they're all coming from a single source. And so the idea is you want a plurality of perspectives, a plurality of opinions, right? Because the less of a clique it all is, the harder it is to get away with shenanigans, right? Because people aren't going to be trusting one another, keep their mouths shut. And so part of what we need is a system where people are coming in from different walks of life, different avenues, so that there isn't this expectation that they can all just hush up abuses of power. And so having a system where lots of people are coming in from different paths makes sense.
So again, that, in my opinion, reinforces what I was arguing with Jed yesterday, that the signature requirement just needs to go away. That anybody willing to put in the work, anybody willing to put their name on that, in that basket, these heads of, the governor and speaker on both sides, I think, or something like that, or leader in the House, leader in the Senate, those are the ones who will pick. Anyway, if they wanted someone specific, they just call that person and say, go, they call up a few friends and get the signatures they need and get them on there anyway. The signature thing is only going to, in my opinion, cause people who might be perfect for it, but don't want to play in that popularity game, to cause them to say, no, never mind. I think it should be, if you want to put your name in, you put your name in, and then those that pick.
I think that the idea of having a signature, a list of support by signature, is not a bad idea, but it shouldn't be onerous, right?
I don't think it's a good idea. I disagree. I don't think it's a good idea at all. I don't, because there's some people who might be perfect for it, that would be willing to do it, that are not going to play a popularity contest for one reason or another.
So here's my thought. If it was solely up to the grower rep, right? Then the government picks somebody that he has already an inside relationship with or whatever, right? To require the signature from the grower means connect outside of just the governor. If you only need 5 signatures, though, that's easy. Governor just to get 5 people to on for this person that he wants. If you need 50 signatures, that's too much, right? Nobody's going to bother to do that. There's a sweet spot, but you know, if every nominee needed 10 or 20 signatures, then what does that mean? That means that they have connections in the industry where 10 or 20 other people respect them as a person who could represent the interests of that sector of the industry. I think that's not a bad idea, honestly. You know, I think that makes sense to me. It can't be onerous, and it can't be a token without meaning.
Deb,
So-
let me ask you what you think on this one.
I'm thinking a little different.
What do you think?
Um, well, I'm not sure I'm understanding how the appointments would come from a bunch of different people. I more saw it coming from like a committee that would appoint it. But anyway, however it goes, the people that are interested can put their names in the hat. They can submit their qualifications, like a resume. And if they want to submit a list of people that endorses them, they could do that if they wanted to. That it wouldn't be like a requirement. That was just my thought.
Okay, so what do you think about, for example, the patient advocate? If it was going to be you could be a patient advocate. You know, how do you feel about having to then go get 50? It was 200, but now I guess it's lowered to 50 signatures from other patients before your hat or before your name goes in that hat.
50 signatures, and I'm back to seeing a doctor a couple times a week because there's something new going on. 50 signatures, I don't, that's a lot.
So it's probably something you're not going to mess with.
No, I don't think I would.
See, that's my concern. That's my concern right there. Is that
Yeah.
that
So
people, go ahead, Lawrence.
right, and so here's one of the things where the devil's in the details. Are we talking about handwritten signatures? Are we talking about just electronic endorsements? So if I were to create, you know, a Facebook page saying, if you think that I should be the patient representative, then put your name here. And then, you know, maybe I get 50 people saying yes. On the other hand, if I had to pound the pavement, so to get 50 handwritten signatures, there's no way, you know.
Okay, but
I have
so
issues myself.
so let me ask, how is this written? Is it the way it's written now? Is it going to require 50 signatures from someone in person?
It's not specific, and that's an issue that I want to go over with Jed about. It needs clarification.
All right, go ahead, Raymond. Go ahead.
I like this topic, definitely. I personally probably could go out and collect 200 signatures if I wanted to. But that, like, so the requirement's 50. What is there going to be, like, somebody, you know, comes in with 500 signatures? Is there a cap on that? Are they gonna, you know, is that gonna look better than someone who just brought in 50 signatures? Is that what
The way it's worded, it just means you got to have that many to get your name in the hat.
Okay, so then
your name doesn't necessarily go with, hey, this is this guy and he has 35, this guy has 70.
Okay.
Just this guy got the required signatures. At least that it doesn't explain enough, I guess, to go into that kind of detail. Lawrence, what do you think? Does it?
It doesn't go into the level of detail, and I do think some of that stuff does need to be spelled out. I think that there's a huge difference between getting those physical signatures versus just getting, you know, something indoor electronic.
Okay.
And I think but I do like the idea of having some demonstrable evidence that you have support from your community. It kind of prevents the government nepotism that otherwise is more likely to happen.
Okay, well, there might be a sweet spot in there somewhere, maybe, I don't know. But let's keep in mind also, we're talking about putting this in the Constitution. We're talking about putting in the Constitution, whatever that sweet spot is, that to get on this board, you're going to be required to do A, B, and C to be considered for the board. And that A, B, and C has absolutely nothing to do with your knowledge of cannabis, your knowledge of government agencies, your knowledge of how the board will work, your knowledge of anything. That A, B, and C is solely and only based on your popularity. It doesn't mean that, well, I guess people say it means you've got people in the industry that respect your view and trust you, or it means you've worked out a deal with those people, and this round you're going to be the one that your little group's going to set up, and the next time you're all going to sign for this other friend, and you're all going to be rigging the whole system for your game for yourselves the whole time. We don't know. As Lawrence said, it does require the goodwill of some people.
Yeah, and I want everybody to really seriously think about this. So let's say, for instance, you're the patient advocate of the Food Safety Board, all right? And there is some grow or processor or whatever who wants the rules to be shaped in a certain way that is to their advantage. And they come to you and they'd say, I'd like you to get this into the new rules. And we'll offer you something for it. You know, I'd like you to do it on our behalf, and we'll pay you. You know, we'll give you a job, we'll give you a whole bunch of free stuff. I don't know what it is. But the fact is that that's sadly the way government works, right? That there's payoffs, there's bribes, spoken or unspoken. You know, there's ways in which people are incentivized to shape government to the interest of industry. It happens at all levels of government with regards to all issues. And so the worry is that no matter what we do to get the right people in, how vulnerable are they in terms of their moral character to basically start letting the offers? It's like we will fund your own dispensary after your term in office if you do these things for us. You know, that's the kind of thing that really worries me.
And let me ask,
but I don't see anywhere to stop it.
Since you said it doesn't have a lot of detail, does it say anything like, how would we keep the patient advocate from being one of these influencers who slings products on their show and gets products or makes money on advertising?
I think that the patient advocate should have no financial interest in any cannabis business, should not receive any compensation from the cannabis business. That if they receive any gifts, they have to be reported. You know, I really think that we you know, that to avoid, because we're talking about, you know, an industry that's in the order of $1 billion here in Oklahoma as it matures. You know, with that kind of money at stake, right?
The big numbers of bribes in the 6 and 7 figures that have moved around this state since the passage is mind-boggling. It really is. So thinking that without enough words to stop all of this, of what we're talking about, it's going to happen. I mean, so I say, pull that out of there. Again, we're going to put that in.
And we also say this, you know, but we also need, I think, a standalone agency, in part because Director Williams, right, only serves at the pleasure of the governor and serves at the pleasure of the head of the Department of Health. The Department of Health is obviously connected into the Oklahoma State Medical Authority, that utterly, you know, is opposed. And so, to what extent behind the scenes are the documents that she's producing, right? Are the rules that she's producing coming through basically institutional pressure that she has to do it this way or else.
Well, I
So,
think
you know,
we all saw the no flower at the beginning of the program, which is a prime example of what you're talking about right there. So, you know, if maybe everybody doesn't remember, but at the beginning of the program, the first set of rules had no smokable flower. So, yeah, they could try just about anything at this point. And they're obviously not fans of the program. So yes, we do need a standalone agency. I completely agree. I don't necessarily dislike everything that's in here. I think it's landing in the wrong place. That's all. I just think it's
I think
landing.
it should be statute versus constitutional.
I think it should be statute. I think some of this should be worked out through the legislator. I think that we have term limits in the state of Oklahoma so that no one can serve more than, 12 years. So we have new group. We got 50 new people in the building this last election. Every 2 years we have a new group piling in there. And I just think that we're making mistakes and putting them in a permanent document. We're doing things that will be obsolete and that could be obsolete in a few years. And we're putting them in a permanent document because we can't lobby through the standard ways of government, of lobbying through government that every other industry does. And I understand it's a different industry. It's one created that was illegal for almost 100 years. So I understand it's different. But again, I just feel like we're making some mistakes here. I applaud the ideas. I'm not sure if the target's right. Deb, what do you think? I keep going to you, but you've been the quietest so far. And then Raymond, I'm going to ask you. What do you think, Deb?
Well, I think it's an awful lot to put in the Constitution. Less is more. And I remember when I used to work on bills, when we try to cut them down, it's just as important. You don't have to put everything in writing. It's just as important what's not said as what is said. I don't know if I'm explaining that right. One thing, when we go about these patient protections, we have agencies that ignore that. And I think there's some wording that needs to be changed. And I can get with you specifically on the Second Amendment stuff because the OSBI is denying access to the SDA for license holders. They won't give concealed carry permits to card holders. And so that denies me my right to carry a gun out of state. You know, the permitless carry took care of it. And when I asked legislators about it, they said, oh, well, I said, they're acting in contrary to Oklahoma law and they're an Oklahoma agency. How about holding up their funds? And they didn't want to do that to make them follow Oklahoma law. So, but Jay Ramey, and it's been well over a year ago, stated some different language that he thought would tie up OSBI. So I'd like to get that language and get that to you.
Yeah, please.
Yeah, we'd love to see that for sure. We definitely want you to go back, read all that for yourself. You say you've got maybe some suggestions on a little bit of the patient protections might be worded a little bit different. As I keep saying, this is going to be wrapping up soon. So everybody needs to get their input in as soon as possible. Raymond, let me ask you, what do you think as we're coming to a kind of a close here fairly soon? What do you think so far?
I think you were wanting me to comment on the content, which is going to go in the Constitution. I feel like I agree with what Deb said. Less is more. You create a committee who can be fluid with what is, the developments of different things that could change in the next 2 years, technology, leadership. So, whenever you have things that are constantly changing, why put them in the permanent document? So, yeah.
Okay, well, what do you think, guys? Are we about ready to wrap it up for tonight?
I think so.
we've gone for about an hour and a half so far, so or almost an hour and 45 minutes. So I think we've covered quite a bit. I know we didn't get to all the language. There's just too much.
Yeah.
And since we need to argue about each little bit of it, some of it we skimmed over. I still want to go back and argue about, and I could do this for about 8 hours before getting tired. So, but we won't do that tonight.
Yeah.
I want to thank everybody for coming on tonight. I want to thank everybody for watching. I wish we'd have had more people watching. I saw we had about 10 or so through most of the show. If you guys don't mind, please share it. Maybe some other people will pick it up. I don't want everybody to wake up the day after this is filed and start asking what's in it and why they weren't asked for their input. Everybody's been asked for their input. So if you haven't gotten your input, you're not being loud enough. Screaming at somebody. Send it to ORCA. Send it to us. We'll pass it to ORCA.
Yes.
There's got to be a way to get it there. There's got to be a way to get your views to the right people, whatever those may be. Okay, well, Deb, you want to say bye to everybody?
Thank you for having me. It was a real honor, and we'll talk at you next time. Thanks a lot. Thank
Thank
all
you,
you guys.
I appreciate you being here. Raymond, what about you?
I got 3 things to say.
Uh-oh.
Democracy, transparency, and grassroots. That's
Okay.
what those are definitely 3 things that I think that we all need. And it's our planet, so plant it.
I was going to say, you got to get that in too. I wanted to get that. Lawrence, what about you? Anything else before we go?
Maybe just sort of a quick point that the full access petition has almost nothing in it other than what we talked about today, all of our rights. It simply says, it's rather than just patient, it says anyone 21 or older. As that, it has expungement and then taxes change. But, all the things that we discussed today, I think speak to the needs that we have in light of 100 years of tyranny. And so, all these protections are needed because we live within this world that hates cannabis. We live within this political system with people with power that basically, have kept their knee on our neck for 100 years. And so we're going to have to keep fighting, because if we don't, we're never going to get these rights back. They're not going to give them to us. And that's what this is about for me. This is about freeing us from their tyranny.
Very well said from all of you. I appreciate it. I want to thank everybody for coming on tonight. I really appreciate it, guys. Sorry we didn't get to the other petition tonight. Again, we will do this twice a week, more if needed. If a bunch of you reach out and say you want to come on here every night and hammer this out, I'll make time. We'll make it happen. So it's up to you guys.
A lot of things we didn't talk about. There's so many things to talk about.
Well, again, I'm willing to do this right now, Sunday and Thursday. If the need is there, I'll do this 7 days a week like we did right when we were passing 788. So we'll do whatever it takes to make sure everybody knows what's going on, everybody's involved, so that when this is done, we're all still sitting at the big table. That's the goal. All right, you guys stay right there. We're going to go ahead and log offline, but you just sit right there. Okay, folks, Sunday night, 6 o'clock. Drenham, and I'm not sure who else will be here. We'll have at least 2 guests Sunday. So until then, stay grumpy. I'll see you on the road.